a human rights lawyer, you know, I decided to talk a bit about the trial of Nnamdi Kanu. It is being alleged, or sort of, it's not allegation anymore. The report reaching me is that the Federal High Court sitting in Abuja has adjourned the matter to 16th of October, because the prosecution team, the prosecution legal team, brought to the notice of the court that they have not been served, or that the defense have not, or that the medical center, yes, the Nigerian Medical Association has not officially filed their findings before the court. So that is their contention. If you look at the last adjourned date, the court ordered the Nigerian Medical Association to investigate, to conduct an independent inspection of the allegation that Mazen Nnamdi Kanu is not feeling fine, or that his health is deteriorating. So the Medical Association of Nigeria were given 8 days by the justice of the Federal High Court that is presiding over the matter to conduct the findings and come up with a report, which they complied with. But according to the prosecution legal team, they brought to the notice of the court that you know that they have not formally filed their report to the court, so which the court actually obliged and adjourned to the 16th of October 2025 to determine the matter regarding Mazen Nnamdi Kanu's suit. But there are a lot of things that has not been quite okay with me as a person that that is to some extent knowledgeable about human right, the fundamental human right as enshrined in chapter 4. If you look at it, and inside that chapter 4, section 33 to section 44 of the Constitution enshrined all the right of Nigerian citizens. Then section 45 is talking about the limitations, and section 46 provides for the court where you can enforce some of these rights. And one of the basic rights that protects a defendant, a person that is facing trial for any alleged crime, is basically section 34. In fact, section 34, section 35, section 36, and even section 33, because the court, there is an important judicial precedent. There is an important judicial saying or judicial axiom rooted in constitutionalism that it is only the living that stands trial. Yes, it is only the living that stands trial. That is why section 33 is also an important tool, an important provision that protects a person, the defendant, in every criminal trial. So, section 34 about dignity of human person. So, wherever a person is, the person should not be subjected to any sort of indignity. And subjecting a person to a detention facility where he does not have access to health falls short of this right to dignity of human person. Then section 35 protects someone's liberty, including the liberty of those that are being charged to court. Then section 36 is the alpha and omega, the the king, the king of fair trial and fair hearing, which is what regulates every criminal trial, fair trial and fair hearing. So, Section 36 of the Constitution is of utmost importance. And if you look at one of the provisions in that Section 36, it requires that a person that is standing trial should be given facilities to prepare for his trial. And that adequate facility involves good health, well-being. That is where the axiom emanates that a person, a person who is standing trial should be well treated with utmost dignity. It also follows that it is only a person that is living that faces trial. So my problem is, why is Nnamdi Kanu's case always different from every other case? The answer is clear. It's because he's an Igbo man. He's an Igbo man. And yes, he's an Igbo man. And I think a high court in Enugu actually agreed with me that proscription of IPOB, which Nnamdi Kanu leads, which his leadership of that team is one of the reasons he's being persecuted, is unconstitutional and also a violation of Section 42 of the 1999 Constitution. Because if you look at the provisions of Section 42 of the 1999 Constitution, it lays against discrimination of any individual on the basis of sex, tribe, religion, etc. So, the act of selective justice in Nigeria tends to violate Section 42 of the 1999 Constitution. And that is why it is uncalled for. Because from all intent and purpose, you can see that the Nigerian state has breached all procedures for fair trial. First of all, when you arraign a person being suspected of committing any crime, the person has no business still being detained in the detention facility of the security agency that is prosecuting the person. Immediately after arraignment, the ideal procedure in criminal jurisprudence, in the administration of criminal justice, is to move the person from the security agency's detention facility to the correctional service. Persons high profile defendant like Abba Kyari were also melted that every other citizen of Nigeria, once he or she is being arraigned in court, the next is that they are either taken to Ikoyi prison or Kuje prison. These are the most popular correctional centers in Nigeria. But in Nnamdi Kanu's case, it became a different ballgame. That is even in Nigeria that you see people, you see the government negotiating with terrorists. But Nnamdi Kanu, who is only agitating for self-determination, a right that is enshrined under Article 20 of African Charter on Human and People's Rights, which Nigerian government ratified and by implication made part of the Constitution. You see, you see the country penalizing, persecuting this person, whereas negotiating with armed bandits that have killed. So you see the double standard? That is why most of us right-thinking individuals are protesting against this. Justice should be done to all equally and fairly. This bias on the basis of tribe should stop, because the only offense of Nnamdi Kanu could be that he's an Igbo man. So it is high time we embrace justice in a country that is already decaying by doing the needful. Nnamdi Kanu has no business being in SSS detention facility. He should have been taken to a correctional service pending when his suit may be determined. If at all, he is not even right to be granted bail. Because in 2017, he was enjoying his bail. And then you sent soldiers who ordinarily are not meant to interfere with civilian matter. The functions of the soldiers, if you read, if you go through the provisions of the Armed Forces Act, the functions of the Nigerian soldier is to protect Nigeria from external aggression, not to meddle in civilian matter. So it is the work of the Nigerian police if a person who is enjoying his bail decides to breach any of the bail conditions, the persons that are meant to actually arrest the person and take him to court, or the ideal thing is even to go to court and seek revocation of the the defendant's bail. If you seek the revocation and the order is being granted, what you need to do is to take the Nigerian police or possibly the SSS to go and arrest the person and take the person back to the correctional center. But what did they do? They sent in flagrant violation of the Armed Forces Act and all due process of administration of criminal justice. They went and attempted to assassinate this man. Then he fled, and now you are saying he jumped bail? And the matter of jumping bail has been settled by the Supreme Court that opined, that stated, that held, that ruled that he did not jump bail, that the court that revoked his bail was even suspect, that the court, in the exact way that is the court that the judge that revoked his bail is very suspect. They said it in one of the judgments. So I don't understand why everything about Nnamdi Kanu or an Igbo man is often different. Let me talk about the international dimension. When Omar Odiko in 1984 was almost subjected this act in United Kingdom, the Nigerian state was sanctioned. It severed the diplomatic relationship Nigeria had with United Kingdom. Of course, Omar Odiko is not an Igbo man. And now that it concerns an Igbo man, Mazen Nnamdi Kanu, who is also a citizen of United Kingdom, United Kingdom has not taken any proactive measures to actually hold Nigeria accountable for international human rights breach. Extraordinary rendition is an international human rights breach. I wrote a project on this as an undergraduate project topic, the legal consequences of extraordinary rendition, which made me found that extraordinary rendition is not just breach of international law and protocol, it's also international human rights violation. So the British government has not even said anything about it. So meaning I don't know why internationally and nationally there is always selective justice when it has to do with an Igbo man. So that is why we all are asking for justice to be done. Yes, if there is any reason whatsoever, the world and the Nigerian state is often doing selective justice when it pertains to Igbos, they should stop it. Look at Lagos State, where you say that we're in one Nigeria. If you look at what is happening in Lagos State, you will see that the Igbo man is being sidelined, that the civil war has not even ended, that they are devising a guerrilla warfare, a guerrilla civil warfare against the Igbo society. So we are calling on the Nigerian state to prove us wrong by first of all releasing Nnamdi Kanu and seek political solution. If you look at the provisions of Federal High Court Act, I think particularly Section 19, it requires that certain matter requires political solution, because treason, terrorism, and related offenses are political offenses that quite requires political solution, because you cannot end people's agitation through court order. You can only end it by negotiation. I wonder why, you know, the state council does not advise the federal government. Though I don't know who is advising who. It could be that it's even the state government, the state government or the Nigerian state that's advising the lawyers instead of the lawyers advising the Nigerian government. There are some matter, there are some issue, there's some legal dispute. You don't do litigation. There are some you just employ alternative dispute resolution. So in matters which you quite know, if you go to Zamfara, all these places where bandits and terrorists are operating, you will see them negotiating with them. So they understand that negotiation is very, very important in certain aspect of life. But my problem is, why is everything that pertains an able man always meted out with selective justice? So it is now time for Nigeria to have a rethink. If you think that the Igbo man is still part of Nigeria, the best thing to do is to bring about equity, justice, and fairness. And how do you show this fairness? By the release of Nnamdi Kanu, and also getting justice for the traders in Lagos State whose property and businesses have been, destroyed, whose shops have been demolished unlawfully without any compensation. Because if you look at the provisions of joint provisions of Section 43 and Section 44 of the 1999 Constitution, yes, it is true that the Land Use Act guarantees expropriation rights, but that expropriation becomes unconstitutional and illegal if you do not give adequate compensation. So you just go into a certain market that the Igbo population is doing business in Lagos State, you just demolish it with impunity. So, and you want these people, and you guys are crying that there are, insecurity in the southeast. You want these people that you demolished their shops and destroyed their place of business to come back home and do what? These are some of the things that leads people to, when I was doing criminology, they will call it criminogenic factors. Failure of the Nigerian state or failure of any government has always become a criminogenic factors. What is criminogenic factor? Criminogenic factors are those factors that predisposes people to commit crime. These are criminogenic factors. So Nigeria needs to, it is high time Nigeria stops certain things. It is high time we do the needful. If you don't want a particular people in Nigeria to have self-determination, what you do is to ensure that there is equity for all. Ever since the Civil War ended, I was not born, I'm still a young man, I was not born during the Civil War. But with what I can see now, I feel that it must have been the attitude of the Nigerian state that, pushed the Igbo man to actually resist in a warlike manner. It is no longer history. Sometimes when we have been taught this history in classes, we tend to blame our leaders for taking up arms against the Nigerian state. But with what is happening now, we are beginning to see reasons why our people had to resist in a warlike manner. But it is now time to bring about that peace that we all want. Or it is not a rocket science. It is not something that, it is not a national reality. It is not. It is not a utopian satire. We've seen so many countries split without bloodshed, without resorting to some of these disagreements. We have example of Sudan. Sudan's split into two: South Sudan and North Sudan. You know, USSR also did the same. There are so many countries. It's not a rocket science. It's not a utopian satire. It's something that we have seen it happen. So, but if the Nigerian state does not want self-determination for the people, bring justice, bring equity. That is all we ask. And how do you start in that journey of ensuring that equity is done in Nigeria and manifestly shown to be done is by releasing Nnamdi Kanu. Thank you.